Welcome back, podcast fans. I'm your host, Annette Hines, and this is Parenting Impossible, the Special Needs Survival Podcast. Today, we're going to talk about a pretty detailed area of trust law and practice regarding pooled trusts. Now, what is the big dang deal about pooled trusts anyway? What is a pooled trust? We need to do a little refresher on special needs trusts because a pooled trust is just another type of special needs trust. Pooled trusts can be either a first party trust, which is a self-settled trust. That trust is funded with the disabled person's own money and has some pretty strict rules and procedures and process around establishing the trust and then funding the trust. But also pooled trust can be a third-party trust, meaning funded with other people's money. And a third-party trust can nominate in writing a pooled trust to hold a trust share for the disabled beneficiary. A third-party trust, whether it's a standalone trust managed by a trustee, who's either an individual or an organization, it has the same flexibility basically. So if you have a pooled third-party trust share, or if you have an individual trustee managing a standalone trust, they're going to have more flexibility than a first-party trust or a trust funded with a disabled person's own money. It's a little less restrictive. Let's just put it that way. So as you may remember, for those of you who have been to this podcast before or who have seen any of the things, been part of our community or done any of the things with special needs companies that we've been putting out there for many, many years. Special needs trusts are a way to set aside assets for a disabled beneficiary, whether they are on public benefits or not sometimes, but who need a little extra support in financial management and who potentially need to protect their public benefits. So that is why we use special needs trusts in our planning. Just a little refresher on language. I know that the term special needs is offensive to many people in the disability community, and I completely understand that. I am hoping that this is evolving now, but as of right now, special needs trusts are a legal term of art. They are specifically mentioned in certain statutes and certain regulations by Social Security as well as Medicaid in your state. And it is just a term of art, and it's not meant to be diminutive or punitive or infantilizing in any way. If you ask 25 people in the disability community what terms they like to use to describe themselves or others, you're going to get a lot of different answers. And it's key and important to ask those questions so that you know the language that people are using to describe themselves. But when it comes to drafting trusts, we very often need to have some quote special needs language in order currently to avoid problems and issues in the public benefits space and even in the financial world as well. Okay, so why a pooled trust? What's so special and different about a pooled trust? Well, pooled trusts, to just go back a little bit, are a valuable solution for disabled individuals who need some support in financial management and also need to protect potentially their public benefits. They are run by nonprofits and generally speaking are well organized with good procedures and checks and balances in place. and can offer a solution for people who don't necessarily have enough assets to set aside for themselves or for another that would be worth having an individual manage. Sometimes pooled trusts are selected because there isn't a good option for an individual trustee. Perhaps there's not a family member or a trusted friend that could or would want to perform this task. A disabled beneficiary may have a funded trust for 20, 30, or more years. And that is a long job to have. Certainly, we would hope for some good succession planning in an individual trust, but a pooled trust as a nonprofit entity, a company, can provide that level of succession planning. A trust officer may come and go, but the organization, the entity itself survives. At least we hope so. And until recently, that hadn't really been a question mark. But in the last couple of years, there have been some unsavory cases of theft or loss perpetrated by several nonprofit pooled trust companies. And there are two big cases that have come out in the last several years that have been particularly concerning. Pooled trusts were meant to give families and disabled individuals peace of mind. But this has certainly interfered with that, has certainly come in and really wrecked that peace of mind that we were hoping would come out of a pooled trust share. Generally speaking, pooled trusts are managed by nonprofits and individuals in those nonprofits that are really motivated to be of service to the disability community. Many get started by family members who wanted to offer a different solution. Certainly, there's a pooled trust in Massachusetts called Plan of Massachusetts that was originated by a team of family members who were motivated to bring about some change and some opportunity for their family members and the rest of the disability community. But now, due to the alleged actions of two different Florida nonprofit pooled trusts, people are questioning whether, pooled trusts are right for them or right at all for anybody, and whether how to have oversight and how to be aware of the risks, the inherent risks involved. Okay, so pooled trusts were created by OBRA 93, which is a section of the sorry, train of thought. Pooled trusts were created by the OBRA 93 statute. That's the Omnibus Budget Reconciliation Act of 1993, along with self-settled special needs trusts as well. This permitted a specific type of irrevocable special needs trust that would be a non-countable asset for Medicaid purposes. And that would also be the same for Social Security as well. A D4A trust is the self-settled individual version of the pooled trust, which is known as a D4C trust. These are also called Medicaid payback trusts because after the person passes away, the remainder interest in the trust must be available to the state that paid medical benefits through Medicaid for the disabled beneficiary up to the extent of the claim that they have, and to any state that paid benefits. So if somebody lived in Florida and then Tennessee and received Medicaid services in both those states, there would be a proportional amount due from the remaining trust assets when the disabled beneficiary dies. The pooled trusts, D4C trusts, must have this remainder payback clause, and an individual trust known as the D4A trust also needs to have that Medicaid payback clause. Most states also have their own pooled trust laws and regulations, and so you would need to look to your state to see what your state's pooled trust laws are. So there's several requirements that you should be aware of in order for a trust to qualify as a pooled trust. First and foremost, it must be managed by a nonprofit. This alone would give many people comfort because they think, and they're not wrong, that nonprofits are governed by a lot of regulations and a lot of rules. This is very true. There are only certain people that can establish a pooled trust share, and that would be a parent, a grandparent, a guardian, a court order, or a competent disabled adult. So if the disabled adult beneficiary is competent to manage their own finances and can understand the irrevocableness of the trust share that they're about to create, then they can create this trust share themselves, and many people do. This account must be funded with the assets of a disabled person as defined by the Social Security Administration. So generally speaking, the person needs to be eligible for Social Security payments. The nonprofit must maintain separate accounts for each beneficiary, but the assets are pooled, hence the pooled trust name, for purposes of investment and management. And this keeps the costs down and makes it possible to have a smaller share, like 25,000 or 75,000 or 150,000, which tends to be too small or too costly for an individual or a bank or trust company to manage. In fact, many banks and trust companies have a minimum amount of investments that they will take. Many times it's 500,000, sometimes it's $1 million or $2 million. Many of the pooled trusts have lower fees than a private bank or trust company managing the trust. And finally, the sub-accounts must be established for the sole benefit, that's another term of art, of that disabled beneficiary, meaning it cannot benefit any other folks. It has to be only for the disabled beneficiary. Some pooled trusts have something called a retention or a remainder interest that the pooled trust can hold back for specific purposes, and those purposes have to be well defined. The nonprofit may be able to hold 5%, 10%, something like that, back in order to fund their nonprofit business and help defray some of the costs and keep the costs low for the beneficiaries that they are serving. So the trust must repay Medicaid in all states proportionally that provided health care to the disabled individual, the beneficiary of the trust share. But Medicaid gets paid back after the retention by the pooled trust. And again, not every pooled trust, most of them do, but not every pooled trust has a retention. So it's important to ask about that. So in recent years, we've had two cases that have come up, the most recent one being in 2024 with something called the Centers for Special Needs Trust Administration, which was indeed a nonprofit. But what happened was they filed for bankruptcy. And through the bankruptcy filing, it was discovered that 100 million, yes, you heard me, $100 million of beneficiary assets were gone. It's way too involved to go into in major detail here on this podcast, but the main issue that happened with the centers, and there was a previous case with another nonprofit that had very similar issues. The nonprofit was doing business with a bunch of related entities where all of the board of directors and the administrative management team were intertwined, of the nonprofit, were intertwined with for-profit businesses that were doing business with the nonprofit, such as Boston Asset Management Company, which was the wealth manager that was investing the money from the pooled trust shares, and several other companies that were run by the same small group of individuals that were for profit and were making money from the nonprofit. But because all of the individuals were roughly the same across all the entities, there were no checks and balances. There was no oversight to speak of. So that is what provided this huge problem. The same thing happened 2 years before, and that pooled trust company was caught up with an SEC complaint. Same issue though. Related entities all doing business with the nonprofit and raking in the fees. In that case, beneficiary money, as far as I can remember, did not go missing. But the centers, again, there's $100 million of beneficiary money missing. In addition to that bankruptcy claim, there are now several class action lawsuits against Boston Asset Management, the financial management company, the nonprofit, and multiple people that are involved in these companies. It's unclear whether any of this money will ever be recovered. And it's unclear whether people's faith and trust in a pooled trust or in a special needs trustee, period, that that faith will be restored. Now, as a professional in this field, I have to say that many, many, many more times, a family member or a friend of the family, individual trustee, is more likely to steal from a trust or to make mistakes that impact or hurt a beneficiary of a special needs trust than a nonprofit or a pooled trust company, or even a for-profit entity like a bank or a trust company or some other kind of professional who are managing trust assets for people. I just have to state that because I know that it just shakes us and rocks to the core. How can we trust anybody? I really want my sister or my cousin to be in charge. That's not necessarily the solution, but a perfectly understandable response to what's happened here. But I think through some diligence and some, really good fact checking and asking questions at the beginning before you set up the pooled trust share, or even select a trustee, a professional trustee, that diligence can go a long way to getting back the comfort and the relief that many people feel when they put a good estate plan in place that takes care of themselves or a disabled beneficiary that they love. Okay, so let's talk about some key areas where you need to ask the right questions and seek information. So first of all, you want to look at transparency and independence of the trust company, the pooled trust share, or the individual bank trust company or professional that you are putting in place. So for a nonprofit, though, a nonprofit pooled trust company, you want to look at that independence factor. Who's on the board of directors? Are they the same group of people that are involved in other areas and other companies? Are they independent from the organization? And by the way, you can find out who the board of directors is and what other things they're involved in by looking at the filed Form 990, which all nonprofits need to file and which is public record. You want to also ask about how transparent are they with finances? So things like how often do they send out statements? How do they do their investment management? Do they have a separate investment management company that's not a related entity? Just going to give you a for example. In our fiduciary company called Special Needs Family Services, we have the same involved people. It's a for-profit company. I own that company and I own the law firm. So we don't have a board of directors because it's owned privately and separately. But we don't do the investing ourselves and we don't do the tax returns ourselves. So we have separate entities that we contract with that I have no ownership in, that are licensed in their own way and are going to protect those licenses. And that provides oversight, right? So most of the funds that we have invested are at Merrill Lynch, although we do have a few trusts that have what I call legacy wealth managers that came with the trust, and we haven't disrupted that. Our CPA firm is someone that we privately vetted and that we've hired to provide the tax filings every year. And tax advice as we need it. We could be doing both of those things ourselves in-house. We would make more money if we did that. But it's really important that we have oversight and a team approach so that nothing gets missed, so that I don't have to worry about staff stealing, so that, we are all working for the beneficiary's best interest. Right? A group approach is always the best approach. So that's why I want you to ask those questions. Who is managing the assets and making investment decisions? How often are you getting reports of what is being spent out of the trust and what are the earnings? Now, having said that, under this 2024 case, unfortunately, that might having independence with the third parties might have helped, but they falsified statements. And when you have that level of interception and interference, and that much of a commitment to stealing from disabled people, it's hard to know what would have changed if people were getting statements more often. So one thing that you can ask for, and not every pool trust will do this, and not every individual trustee will do this, is you can ask for monthly copies of the statements from the investment advisor. If it is an independent investment advisor, investment manager, you can look and see if the statements that are being created by your trustee match with what you're seeing in the bank account and in the wealth management account. So yeah, that threw me a little bit when it was alleged in the case file that the centers were creating false statements. So the second thing outside of transparency and independence that you need to look for and be aware of is good communication. That communication can be challenging with some of our beneficiaries. It really can. Many of our people are under stress, have certain health conditions or mental health conditions that make it difficult to have good communication. There's just a lot going on. But as the person creating the pool trust share, whether it's the disabled person themselves or a family member or a member of that person's team, how easy is it to talk to someone at that pool trust and get the answers to your questions that you require? Do they feel evasive? Do they feel vague? Does it seem like the staff that you're speaking with are not well trained or informed? Are the staff patient? Do they timely return calls or emails? Do you have a good understanding of the communication policies and how to reach out to people? Are the staff consistent, or are you always talking to a different person, a new person? So those are the kinds of things that you want to ask about and check in with to see if not only is this a good fit for you, but gut check. How are you feeling about this nonprofit and their ability to manage a small or a large trust share for a disabled beneficiary? And are their policies and procedures documented and available to you? One of the things that really irks me is when I'll be speaking with not just a nonprofit pooled trust, but person who's at a government agency or a nonprofit that has been, um, you know, part of the team for a disabled beneficiary, whether it's a vendor agency providing day support services or residential support services or some other services. Sometimes it's a bank when I'm trying to get some business done for a client or a disabled beneficiary. But what irks me is when someone will quote, well, that's the law, or that's our rule. And, as the detailed person that I am, I will always ask for a copy of that rule, that regulation, that law. And most of the time, people can't provide it. So are the policies and procedures around distributions and investment management and everything readily available to you? Are they on their website? Are they, transparent? Now, having said that, I will tell you that our fiduciary company does have a set of policies and procedures, and they are in writing. And generally speaking, we don't like to give them out, to be honest. Our beneficiaries sometimes can be quite challenging and are not always easy to work with and do not always have the ability to sort of self-regulate and to evaluate the policies and procedures that they're being given. So case by case basis, whether we're going to hand things out. However, there are certain things that we are very transparent about. Distribution policies are in writing. We have a specific form that we ask people to fill out, and once a year or more, but at least once a year, we get together with people to set a spending plan for the year, which we send to them in writing once the plan has been established, so that everybody understands what things will routinely get paid for, what things are budgeted for, what things can you ask us to pay for in more of an emergency or crisis situation. And that goes right along with getting the annual budget or the annual accounting for the trust so that you know what got spent in what categories. So policies and procedures are very important. And that is going back to the whole issue of transparency. Okay. Lastly, if you are looking at a pool trust, you do want to take a look at the two documents that establish that pool trust. They're called a joinder agreement and a master trust agreement. You may not always know what you're looking at, but there are some things that'll probably jump out at you. And you do want to look at things like, what is the remainder or retention policy? And that should be written right there. Um, how do they use the funds that they're retaining? And remember, not every pool trust has a retention. But if they do, how do they use those funds? Are they just going to pay for general administrative costs? That's neither good nor bad, but you do want to know, what are these funds being spent on? How much got retained last year? If you look at the public filings, you can see what the numbers are for the operations of that pool trust nonprofit in the past year or two or three. And you can see what the bottom line is for the retention and, how is that being spent? But ask the questions and see what the response is that you get. Feel free to hire an attorney in this area of law to help you review the jointer agreement and the master trust agreement and the retention policies and explain them to you and answer your questions. It may be the best money that you've ever spent, and certainly shouldn't be more than a few hours to help you with that or less. So, all in all, don't be discouraged. Professional trustees, nonprofit pool trusts as a trustee are often a very good deal. Some pool trusts have social workers and case managers that can assist with things beyond just managing the money and distributing and paying for things. Some specific fiduciary companies like our company have very specific trained staff who, work very closely with disabled beneficiaries and can provide some additional supports. There's a lot of good reasons to go outside of your family and friends circle, namely one of them being that for a small cost, you can get professional investment management, you can get professional management of the trust, you can get a dispassionate person or team that can work with a disabled beneficiary and won't have all of that personal baggage that goes along with sometimes being a sibling or a family member who, can remember back when mom or dad paid for that bike that, so and so sold or wrecked. And there's just a lot of challenges when it comes to family history. That's not true for everybody. Some family members are a great choice for trustee. And with a little support by a professional team, like a CPA, like an attorney that can go over the rules with them, they can often do an amazing job. Listen to your gut. If you are creating a trust and you are interviewing trustees and thinking about who's the right trustee, you'll come up with the right decision for you and your family member. Also, if you are exploring a nonprofit pooled trust and your gut's telling you that something is just not quite right about the answers that you're getting or the communication that you're having, trust that too. It may not be the right fit for you. That doesn't mean that it's not a bad place for other people to pool their money, but it just may not be the right fit for you. If you need additional support, I want you to know that we have some great master classes, one on estate planning and special needs planning that goes over what a special needs trust is and what a pooled trust is and where it fits into your estate plan. But we also have a very specialized master class on special needs trust administration. It's a few $100s, sometimes goes on sale. And I'm going to leave you a special coupon code in the show notes. If you would like to go ahead and sign up for this course and get some more detailed information about managing and running a special needs trust, this can help you make a good decision about who is the right person or what entity is the right entity to manage this pooled trust for my person that I'm planning for. So I will go ahead and leave that connection in the show notes for you to jump on and take a look at those courses, as well as a coupon code for you. That is your gift for listening to this podcast to the end. Thank you so much. I hope this was helpful, and I'll catch up with you soon. Bye for now.